Resource webinar series. Today's topic is employment decisions in the face of COVID-19. I'm John Musella with the Santa Cruz Valley Chamber, and I will be hosting today's webinar. A couple housekeeping notes about today's webinar. All participants joined in the call are in listen-only mode to allow presenters to share their information uninterrupted. If you have called in, please make sure your phone is on mute as well. The system will remove you from the webinar if you are not on mute. We will have a question and answer session at the conclusion of the presentation. If you wish to ask questions, please use the chat feature located at the bottom center of the screen. The chat icon is a center icon. If you hover over it with your mouse, it will turn blue. You can then click on it and a chat window will appear on the right side of your screen. Simply click at the bottom where it says enter chat message and type your question. Press enter when you are done and your question will go to the host. If during the call you are experiencing any difficulty, please email hello@scvchamber.com. That is hello@scvchamber.com. We are monitoring that email live during the webinar to assist participants. If you're just joining the call, we are going to begin the call now, and please remain in listen-only mode. Thank you again for joining the SCV Chamber's COVID-19 resource webinar for employment decisions in the face of COVID-19. Today's presentation is brought to you by Poole, Shaffery, and Koegle, and our presenter is Brian Koegle. During this challenging time, the SCV Chamber has activated its rapid response communications program to get information out to our members and the entire business community. This webinar series is part of our effort to provide original and relevant business content for the business community. In addition to our email communications you should be receiving, the Chamber created a COVID-19 page on our website specifically with business-related resources for you to use. Please visit scvchamber.com where you can find details. And we are, of course, on social media, Facebook, Twitter, and LinkedIn. More information there. For our Chamber members, we sent notice earlier today that we have extended all memberships for 30 days in an effort to support our business members. I also want to remind you all that we have upcoming webinars, including the following. We have Your Guide to Survive and Thrive on Tuesday, March 31st at 2 p.m. presented by Roger Dumanian, a business consultant and coach. Also, in partnership with the Small Business Development Center, the SBDC, the Chamber is hosting a special webinar on Wednesday, April 1st at 2 p.m., providing critical information about resources and assistance available to businesses affected by COVID-19. You can register for those events on our website at scvchamber.com. Finally, we are in the process of conducting a survey of local businesses and how you've been affected by the COVID-19 pandemic. Please take a moment today to participate in that survey. We will be sending a link via email to all participants following the call with the link. We'll now begin our presentation. Brian Koegle with Poole, Shaffery, and Koegle will now begin. Brian?
Thank you, John. Ivan, SCV Chamber, very appreciative for you coordinating these efforts to get education out to the hands of small business and mid-sized business in the Santa Cruz Valley. I'm forever indebted. This is part of my mission, my goal as an attorney is to make sure that everybody has the information in their possession to make the best possible business decisions. It has been a whirlwind of a week. It was 1 week ago today that we had our first in a series of COVID-19 update seminars with the SCV Chamber. And since that time period, we now have one federal bill waiting on the second. We have a County of Los Angeles Safer at Home program. We have a State of California Stay at Home program and much, much more. We're going to do the best that we can to consolidate this information so that we can get it out to you as quickly as we possibly can. We're going to spend the first 45 minutes of today going through basically lecture style, some of the new changes and updates. I was hopeful to have a Senate bill to discuss with you today. Unfortunately, our legislators have not been able to pass a bill just yet, but throughout today, we're going to comment on some of the items that we know are in the bill currently and that we anticipate will be passed. So we will help you stay on the cutting edge of things. So with that, we're going to jump right in. Slide number 1, please. Since we met last Tuesday, the Congress and President Trump have successfully passed the what we'll call stage 2 of the full-blown stimulus bill that is to apply to all American businesses. The first stimulus bill was done to free up capital in order to help states out from an emergency standpoint. That doesn't really affect small to mid-sized businesses up front, but the second portion of the stimulus bill certainly does. And then, of course, the third piece of the pie is the Senate bill that is currently pending. So on the evening of March 18th, last Wednesday, President Trump signed into law H.R. 6201. That is known as the Families First Coronavirus Response Act, FFCRA. But for purposes of today, I'm going to refer to it as H.R. 6201 because that's easier to say. As part of the resolution that was signed into law, the bill becomes effective for all businesses on April 2nd, 2020. There was a 15-day stay period between the day that it was signed by the president and the day that it became effective by its own terms. One of the reasons for that is because the Congress recognized that they had to figure out a way to fund what is in H.R. 6201, and we'll talk about that as we go through today. By its natural term, the bill will sunset on December 31st of 2020. That means this is not a recurring bill. This is not going to be for multiple use over multiple years. It is specific and intended to apply to the COVID-19 outbreak that has resulted in many states shutting down operations. But fundamentally, it is deemed to be a short-term fix to a longer-term issue. This bill, it does apply to every business in the United States with fewer than 500 employees. The Secretary of Labor was tasked with carving out those industries and those businesses that will not have to comply, those that will be exempt. That exemption was supposed to have been published on Monday, the 23rd. Due to issues at the Secretary of Labor's office and within the Department of Labor, they have pushed off that deadline until tomorrow. So unfortunately, I can't give you a whole lot more detail on this except for a couple of points that are being discussed. First, specific industries such as healthcare, nursing, emergency services are all going to be specifically exempted from the provisions of H.R. 6201. Why? Because these are our frontline defenders at this point. We can't allow them to take significant time off given the emergent nature of the COVID-19 outbreak. The second possible exemption is for those businesses that have 50 or fewer employees. The concern is, in the bill originally, H.R. 6201 indicated that unless a business is able to show extreme financial hardship, the provisions of all of this bill will apply to the business. Hard to say, but I think that each and every one of us on this call today has undergone extreme financial hardship over the last 15 days, but it will be interesting to see what the guidelines are from the Secretary of Labor as to what exactly is required, because remember, this is a burden that falls upon the employer to prove that they are in fact exempted, and they must get leave from the Secretary of Labor before they are actually approved to be exempted. So what does that mean? Unless you do a whole lot of legwork, you are going to have to comply with all of the elements of H.R. 6201. And what exactly is in the bill? Well, there are three major provisions that you need to be aware of. The first is emergency paid sick leave. The second is emergency family medical leave. And the third are the tax credits on how this is going to be paid. Next slide, please. As part of the foundation for H.R. 6201, we need to talk about what it provides first. Understanding that this is a bill designed to protect American workers first, with the financial burden sticking with the employer at this moment until such time that we have more information from the federal government. What is provided? Every employee who works for a business with 500 or fewer employees is going to be entitled to 80 hours of paid sick leave if they were scheduled as a full-time employee. For those of you who have part-timers, it will be prorated based upon the number of hours that they contribute to a regular work week. For instance, if you had a part-time employee who worked 24 hours per week, that is basically the equivalent of 60% of a regular 40-hour work week, that employee would be entitled to 60% of the 80-hour benefit, or 48 hours if you want to do the math. The interesting thing about the paid sick time is that it is available for immediate use, regardless of how long the employee has been employed with your business. If you hired them 2 days before the COVID-19 outbreak, they will be equally available to have this benefit as much as a person who has worked for you for 20 plus years. The leave requirements for paid sick leave apply to 6 categories of employees. I've split these up, as you can see, in bullet point style. We're going to talk about the first 3 as a single group, and then the second 3 as another group. So in the first 3, the individuals who are going to have leave under this bill are those that are subject to federal, state, or local quarantine, or have been ordered into isolation related to a diagnosis of COVID-19, meaning that they are positive for COVID-19. The second group are those who have been advised by a healthcare provider to self-quarantine. These are usually individuals who have been in high exposure areas, or they have an immediate family member who has tested positive, and therefore it is likely that they are a carrier at that point. But it must have a written advisement from a medical provider that they are to self-quarantine for a period of time. The third group in batch 1 are those who experience symptoms of COVID-19 and are currently seeking a medical diagnosis. We know that some of the original testing kits took as much as 6 to 8 working days before a diagnosis was returned. If they have gone in, sought treatment, and have confirmed that they are being tested, they would be entitled to this leave. These first 3 groups, in batch 1 we'll call them, of individuals, would be entitled that during their 2-week pay, their 80 hours, or prorated 80 hours if they're part-timers, that they would be entitled to 100% of their regular rate of pay during the time period that they're away. What does that mean? That means that the employer is responsible for continuing to keep those individuals on payroll as though they had worked their regularly scheduled work week. They were scheduled to work 40 hours, you compensate them for 40 hours. Now moving along to the second batch of individuals, the last 3 bullet points. These are individuals who are caring for an individual who is subject to either of the points above, meaning that they are in isolation because of a diagnosis, they are awaiting a diagnosis, or they've been advised to self-quarantine. Anyone who is caring for a son or daughter due to school or daycare closures. As we all know, throughout the Santa Clarita Valley, and I believe throughout all of LA County, all schools have been closed. Santa Clarita Valley schools just updated everyone that they will not be reinstituting any earlier than May 5th, and that they are taking into consideration through the end of the school year suspending services. And finally, those individuals who are experiencing, quote, substantially similar conditions to those of COVID-19 without a diagnosis. These are the 5 designated symptoms that are identified by the CDC. Primarily above them are a fever above 100 degrees, a dry, a non-productive cough, and any kind of respiratory issues, including shortness of breath. So if they're showing those symptoms but have not tested positive, they would also be entitled to leave under these batch 2 requirements. Under these last 3 bullet points, these individuals are not entitled to the 2 weeks full paid leave. Rather, they are entitled to 2/3 of their regular rate of pay for the 2-week period. Please note that these two batches of individuals, it doesn't become a continuous leave. It doesn't mean that you can take care of yourself for 2 weeks, and then if a family member becomes ill, you take an additional 2 weeks. This is a combined 80 hours or 2 weeks of paid sick leave. If you're caring for an ill student or an ill family member for the first week, you get paid your 2/3 sum. And then if you yourself come down with the illness, you would then take the second week at the full rate of reimbursement, the full regular rate of pay. I will tell you that this is the minimum that is being required. There are many businesses that are out there that are doing more than just the 80 hours. If nothing else, they want to quarantine and keep people away from their other workers to stop the spread of the COVID-19 virus within their workplace. We are only simply talking about the minimum threshold requirements today. So as to those batch 2 individuals, the individuals who are caring for someone else, taking care of a son or daughter whose school is out, why 2/3? Well, 2/3 is basically what the federal government believes to be the take-home pay after taxes that an individual would be entitled to receive during this time period. The 2/3 benefit is non-taxable when it comes through payroll. Whether or not we agree with that politically or not, they are treating these two groups differently. However, they are still to be paid by the employer. That means that it is your financial responsibility as the business owner to ensure that your employees are paid during this time period. Taking one step back to the earlier slide that we had discussed, this becomes effective on April 2nd. Only those employees who are employed with you on April 2nd are entitled to this benefit vesting, meaning that if you have already undergone any kind of reductions in force, layoffs, furloughs of employees, those individuals would not be eligible for these benefits. They would basically be forfeit. So these are the requirements of the paid sick leave under HR 6201 that will coincide and work cooperatively with what we have on our next slide, if you please forward the slide, which is going to be the emergency family and medical leave. Under federal law, employers are generally required to provide family medical leave if they are a larger employer, 50 or more employees. As part of the General Family Medical Leave Act under federal law, an employer has to provide job-protected leave for up to 12 weeks for an individual to care for their own serious health condition or the serious health condition of an immediate family member. That means they're allowed to take time off from work, generally unpaid, in order to care for those illnesses or injuries. Congress has decided to expand the provisions of the Family Medical Leave Act to include leaves associated with the COVID-19 virus. And who is eligible? Well, under the Emergency Family Medical Leave Act, it is only those employees who have been employed with your business for 30 consecutive days prior to taking any leave of absence. So that same employee we spoke about on the last slide, who would have been immediately available for the paid sick leave, is not necessarily qualified for the emergency family and medical leave until they have completed work for 30 consecutive days. Eligible employees who have satisfied that 30-day requirement are entitled to take a maximum of 12 weeks of job-protected leave. That is inclusive of the first 2 weeks being covered under the Emergency Paid Sick Leave Act. In other words, the first 2 weeks would be covered under Emergency Paid Sick Leave, and then anything beyond that would be covered under the Emergency Family Medical Leave Act. It is intended to apply only to those employees, who cannot work or perform telework, basically work from home, because their minor child's school or child care service is closed due to a public health emergency. So this is an expansion on previous leave laws. Obviously, specifically here in Santa Clarita, schools will be closed all the way through the month of April. So we're looking at an additional 5 to 6 weeks at the very earliest from today's date that these benefits will be available to your employees. Please take note that the first 10 days of this particular leave is deemed to be unpaid. Now, it is okay that the employer asks if the employee would like to use any other accrued benefits that they may have, including mandatory paid sick leave that they may have in the bank, any vacation time, or any PTO, paid time off, that they have accumulated. Unfortunately, the employer cannot require an employee to exhaust all of their paid leave as part of their process of taking family medical leave. In other words, you can ask, but you can't force the employee to take that time as paid time off. They can elect to take it as unpaid. Under the Emergency Family Medical Leave Act, it is treated the same as the Batch 2 individuals on the previous slide, meaning that they are to be paid no less than 2/3 of the employee's regular rate of pay. Interestingly, this has a specific limitation, though. The employee is not entitled to receive anything greater than $200 per day or $10,000 in the aggregate. That means that if you have a high wage earner who elects to take emergency family medical leave, the maximum benefit that they can receive while they're away is $200 per day. All right, so let's talk about some practicalities. This obviously can put a significant burden, especially on those small employers out there. Being without an employee for 12 weeks could put a significant kink in the production, in the business model of any small business. Secondarily, having to pay that employee to care for their child at home is a financial burden upon most businesses. As I mentioned on the previous slide, we are awaiting clearance and confirmation from the Department of Labor such that they are going to be providing us guidance as to which employers are specifically going to be carved out. I participated in a call last Friday afternoon with the United States Department of Labor where there was a discussion that employers that had, we call them ultra small employers, with 25 or fewer employees would automatically be exempted from this provision. The U.S. Department of Labor is considering that. We do not have any guidance or clarification yet. We should have that within the next 24 hours because the Department of Labor has pushed back their deadline on their guidelines until the close of business Eastern Standard Time tomorrow, March 25th. I will provide that information to the Chamber of Commerce as soon as it becomes available, and we'll ensure that everyone who is on this call today will receive those notifications. The other portion that we are waiting from the U.S. Department of Labor on is the required posting that must go up in order to notify employees of the rights under H.R. 6201. That also was supposed to have been provided on Monday, but got pushed back until tomorrow. This is a poster that can just be printed from your work computer, posted in a conspicuous location in your business or workplace. I like to have it someplace where all employees can congregate or come into the break room or something along those lines. It should be near or close to where your general labor law posters are already hanging. For those employees who are telecommuting already, working from home in other words, those individuals should be sent a copy of the notification via email with confirmation on read receipt to confirm that you were able to deliver it to them. So those two pieces of information we should have within the next 24 to 36 hours, and we will make sure that all of the attendees on today's seminar receive a copy of that. Okay, next slide, please. So the question that most employers have is, how in the world are we paying for this? Well, the government has come up with a tax credit plan. We only have the skeleton. here are a few points that we do know as we sit here today. Employers are going to receive a payroll tax credit to help offset the costs of these leaves. That means that as long as you have benefits that you're paying to your employee, you can deduct that from your monthly payroll taxes that you would be submitting up to and including basically a zero balance. The tax credit limits are very fascinating. In the paid sick leave realm, the individual tax credit is only $511 per day. I say only, but that's a significant sum. That translates to anyone earning a salary of $133,000 a year, basically. But for those of you who have high wage earners, or those of you who have high commission earners, and let me make sure I'm clear on this. When we talk about regular rate of pay, which I talked about at the beginning, the employee is either entitled to 100% or 2/3 of their regular rate of pay. Individuals who draw much of their income from commissions or bonuses or performance-driven incentives, their regular rate of pay will take into consideration those calculations. How do we figure that out if we have a commissioned employee? Well, that diverts back to the Fair Labor Standards Act, and that means that we actually have to take an average of their last 90 days of commissions or bonuses or incentive pay and include that into our regular rate of pay calculation. Unfortunately, under the new bill, the employer is only entitled to take a credit of up to $511 per day. Anything above that is not going to result in reimbursement or an accounting back to the employer. That falls upon you as the employer to bear that cost. On the other leaves where the compensation is limited to 2/3, in other words, if they're caring for a son or daughter who is out of school, or they're caring for an ill family member when they themselves have not been exposed to the virus, the maximum benefit that you are allowed to cap an employee at, if you choose to, is $200 per day, because that also happens to coincide with the reimbursement that the federal government has approved of $200 a day as a tax credit. We do not yet have guidance on the process for credit processing and reporting to the government to ensure that there is no fraud. We are awaiting those guidelines. However, I do not anticipate those are going to be out before the April 2nd rollout on this plan. So we're going to have to kind of stand pat and wait for guidance on how we report that information. So I've saved it until this point because I find it very ironic, and I think many of you may be thinking the same thing, which is, well, why does this apply to only those businesses with fewer than 500 employees? Why doesn't it apply to the Walmarts of the world or the IBMs or the Boeings? Well, as part of the negotiations in getting this bill passed through the House Democrats wanted this to be for smaller employers because, one, they didn't want to provide these tax credits to larger businesses that we just talked about. And two, the presumption from House Speaker Pelosi was that larger businesses already should be providing at least these types of benefits to their employers. I think many of us may know of some businesses that don't do this. I don't know whether or not businesses will self-administer or self-comply with these obligations if it's not being forced upon them. But at this time, it is only applicable to those businesses with 500 or fewer employees. Okay, so that takes care of what we wanted to discuss today on HR 6201. Next slide, please. I do now want to bring you up to speed as to what's going on here closer to home. On Thursday afternoon, the County of Los Angeles was the first to host their press conference where it was announced that the entire County of Los Angeles would be subject to the, quote, safer at home process or procedure of basically asking all Angelenos who are not part of an essential business to stay at home, to work from home where possible, but not to come into their regular workplaces unless they were specifically exempted. The County of Los Angeles, as part of That guideline published a very comprehensive list of the industries, of the businesses, and of the workers who were specifically exempted as essential businesses as part of that plan. At the conclusion of the County of Los Angeles's press conference on Thursday, Governor Newsom took his own press conference, and he took the opportunity at that point to announce a statewide stay-at-home requirement, directive, for all Californians. Pursuant to the executive order, it was effective immediately at midnight on the 19th of March. And unlike the Los Angeles County provision that was set to expire on April 19th, the statewide stay-at-home is indefinite. There is no specific end date of the stay-at-home requirement. This morning in a press conference, Governor Newsom said that he could see this lasting several days, possibly up to 90 days, beyond the 30 days that have been administered by many counties in the state. As part of the definition in the executive order of who this rule applied to, meaning who had to stay at home, who had to telecommute, who was supposed to not come into work the following day, there were essential, critical infrastructure workers that were defined. Unfortunately, the definitions that were available on Thursday night were very vague, were not very specific, and had not taken into consideration many of you who are on the phone today. So, over the last 5 days, local organizations such as the Santa Clarita Valley Chamber of Commerce, the SCV EDC, Economic Development Corporation, and others have been working in conjunction with our local elected officials in order to make sure that the businesses that operate as essential, as critical to the ongoing economy of our state are allowed to be deemed exempt from the stay-at-home order. On Saturday morning, there was an expansion of the definition of an essential critical infrastructure worker. And then again last night, on Monday night, this 22nd, there were additional occupations that were added into those definitions. I provided you a link to the federal government website that has the up-to-date list of essential critical infrastructure workers so that you can take a look at it and determine whether or not your business falls within the parameters that are laid out. I will caution you. You should do this with a competent legal professional. Why? Because not all businesses fit 4 corners into one of the groupings. If you think you fall in between and you say, oh, well, I fit a little bit into this business model and a little bit into this sector, you need to be very, very wary about considering yourself an essential business, because if you are incorrect, the penalties are severe. Not only is it fully enforceable from a civil order standpoint, possibly shutting down your business, but it is also subject to criminal penalties, including a misdemeanor that results in a $1,000 fine and up to 6 months in county jail. The individuals that would be held liable for such a decision include any director, officer, or managing agent of the business enterprise. That means that you as CEOs, general managers, etc., could potentially be individually liable with criminal penalties in the event that you have guessed wrong. So make sure you're speaking with competent legal counsel to ensure you're getting advice to confirm that you are an essential critical infrastructure worker before you're directing your employees to come back to work. Now, before I move on to the next slide, I will tell you this much. A lot of folks that are in even these essential business areas are actually having most of their workers work from home, just from a general best practices, protocol and procedure. For instance, I work in a law firm. We have a specific carve-out as an essential legal service provider, and we have provided most of our employees the option, whether they choose to come in or whether they choose to work from home. A large majority have chosen to work from home in that circumstance. The beautiful thing about our business model is that works. We are able to have folks work remotely. Many of our friends in manufacturing do not have that option. Somebody cannot sit behind a CNC or a lathe machine while they're at home and program and operate the machines. The same can be said for many service-based industries. So be aware of the fact that just because you are an essential business, it does not alleviate the burdens that we have as California employers to continue to interact with our employees, to discuss with them what is and is not a reasonable accommodation, and providing them every opportunity to keep themselves and their families safe during this time. The next slide, please. So I want to end my lecture portion of today's presentation by going through some employer best practices. I think most of these are common sense, but it goes without saying that there's always one or two people who say, oh, wow, never thought of that. So it's always worth repeating. First and foremost, we need to make sure that we're posting all of our notices for employees so that they know what their rights are, and they also know that you, the employer, are taking this seriously. As I've mentioned a couple times before, we are waiting for the United States Department of Labor notification of rights under H.R. 6201. We should have that within 24 to 36 hours, and we will most certainly send that out to everyone who is on the call or on the webinar today. Second, Cal OSHA published a mandatory notice on March 6th. I've sent this out a couple of times to most of the businesses in Santa Clarita. If you do not have it, here is a web link. It's basically the OSHA 3989 form. It is a mandatory notice to put up for all of your employees to see from a health and safety perspective in the workplace. The third notice that I've indicated and listed here for you, this is just a best practice. These are the CDC guidelines on maintaining a healthy workplace. Talking about best practices, maintaining social distancing, washing your hands, cleaning off common area surfaces on a regular basis. The 101s of what we've heard on the news for the last 4 weeks ad nauseum, in writing, putting it in front of your employees just as a direct reminder so that they cannot argue that they didn't know in these circumstances. My second best practice point on this is to communicate with your employees. This is a really difficult time for many people, especially employers. Leadership is always difficult. It is always a circumstance that we as managers, as C-suite individuals, as small business owners, we're called on to make some difficult decisions. But communicating with our employees and our teams are all the more important right now in a time where everybody is apprehensive. One of my favorite authors, Simon Sinek, says, leadership is a choice, not a rank. You don't have to be a business owner to show leadership opportunities. Making sure that you have written policy revisions to reflect mandatory paid sick leave as required in California and now under federal law. Talking about some of these best practices with your teams so that they know what you're doing to help protect them, to help shield them from the disease. Providing positive reinforcement, making sure that you're appreciative for when they are, in fact, working long hours as on a work from home or a telecommuting basis. These are all great best practices for you to consider in your business, not just in the eye of COVID-19, but moving forward. I've put this as a separate bullet point only because I've got to keep saying it. Please maintain social distancing. If you aren't able to meet with your clients remotely using webinars, using teleconferences, and you actually have to physically be present, no need to shake hands, no need to give hugs right now. Give your 6-foot radius a little bit of a break and stay away from people as much as you possibly can. The more we do to flatten this curve, the better off everyone is going to be nationwide, and the sooner we're able to get back to work, and that is best for all of us. And then finally, sadly, you have to make an assessment on your business continuity. During this time period, if we are in fact all shut down as non-essential businesses for a period of 30 days or longer, do you have a viable business enterprise on the other end? Is this a time for you to start trimming some of the fat, either reducing hours of affected employees, furloughing some employees who may not have enough work to do over the next several weeks, or ultimately making the decision to lay people off based upon economic need? Each one of those three decisions should be done carefully and slowly, usually with the advice of counsel. Each one of those requires a written agreement or statement to your employees so that they have written notification of their change in circumstance. You can feel free to reach out to me. I've got change of status on all of those type of scenarios. I'd be glad to share those documents with you if you'd like them. A couple of points that I do want to point out that many people are not aware of in California. In the event that you furlough an employee, meaning that they are off the books, they are not working for you, not receiving any hours for at least one payroll period, you must treat it, at least from a labor law standpoint, as a layoff. That means if they've got any accrued but unused vacation or PTO time, you must cash that out when you furlough them. While they may remain on inactive status, you need to talk to your payroll company to figure out how long you can keep them in that role. Some of them say 30 days, some say 60, some say we don't have a limitation. A furlough doesn't have a magic wand on a specific date. The third consideration, if you're looking at these things, are benefits. Do you have a group health care plan? What does your plan say about an employee who's unable to work for a 30-day period, 60-day period? Make sure you're going through all of these before you make your decisions, because all too often we jump thinking, oh, we've got to just cut everybody because there's no work to do. And it becomes a far more burdensome economic pain than if we had just slowed down, made the decision slower, and taken into consideration other options. Go ahead and click to the next slide. So that covers all of the basics that we wanted to go through today with you. I'm running almost right on time. That is perfect. I wanted to make sure that I allowed enough time for Q&A because I know we have a couple hundred folks online today. This is your free shot to ask questions and not have to pay the $500 an hour that it normally runs clients to ask the attorney the tough questions. So with that, I'll turn it back to John and his team to bring up any questions that may have been asked.
Brian, thank you so much for that great presentation. Yes, you are a popular guy. So many folks on the webinar today. I just want to remind everybody that we will have a copy of the presentation that's going to be sent out to each of you via email after this call, as well as a link to conduct the business survey we mentioned at the beginning of the call. We appreciate your participation and all that. So we're going to go over to Q&A, and again, you can send your questions to the chat if you have questions. Our first question is from Howard Miyoshi from Airframe Man. And Howard would like to know, we are under a state and local isolation order, but we are an exempt business. Can our employees claim emergency paid sick leave?
All right, so that's a great question. In the event that you are an essential business or an essential infrastructure business at the statewide level, then the mandatory sick leave application of a federal, state, or local government, for lack of a better term, quarantine does not apply. That is not an automatic trigger for your employees to receive the 80 hours or 2 weeks of paid sick leave. It is only for those non-essential businesses where they are not allowed to work and the employee cannot telecommute or work from home. If they're able to work from home and you're able to give them work, they do not have to receive the mandatory paid sick leave, even if you are a non-essential business. But for those essential businesses, that first provision, that first bullet point of tranche 1 does not apply, triggering the sick leave requirements. Thank you, Howard.
Okay, Brian, our Second question is from Magda Forsberry from DVL Media Co. She'd like to know if an employee has used some of the 80-hour sick leave before the COVID outbreak, are we using a complete new 80 hours or minus what they've already used before the outbreak?
Great question, Magda. If an employee has already taken time before April 2nd related to the COVID outbreak or related to a COVID illness, you do receive credit for the previous time that you've advanced to them, as long as it met the minimum mandatory requirements of the state leave or of the federal leave. In other words, as long as you paid 100% of their sick leave while they are away for their own illness, for their own quarantine, or while they were awaiting their diagnosis, if you paid that 100%, you will be covered, and you can take that as credit against the 8 hours. Thank you.
Okay, Brian, next question. Rochelle Patterson from SCV Water would like to know, how would the Emergency Family Medical Leave Act work if you have an employee who will use it intermittently to care for a school-age child?
Excellent question, Rochelle. The way that the bill is written right now is that all the general rules and regulations of FMLA leave would apply. Because there are provisions for intermittent leave under FMLA, we would have to honor those same intermittent leave requirements under the emergency family medical leave. What you are permitted to do under FMLA is you're able to ask the employee so that you can plan for workload. Well, how do you plan on using this intermittently? It's possible that one spouse needs to stay home on, let's say, Mondays and Fridays. The other spouse needs to stay home on Tuesdays, Wednesdays, and Thursdays. You can ask for that clarification up front. They are permitted to take it in intermittent portions, and it must basically be equivalent to 12 weeks at 5 days per week, so 60 days of FMLA leave that would be applicable in that circumstance.
All right, next question, Brian, is are employees allowed to telework, work from home, even if we are not an essential business?
Yes, absolutely. Even if you are not an essential business, you can have your employees work from home or telework if your business model allows for it. In the event that you do that, though, I do want to caution you, California Labor Code 2802 requires that an employer reimburse all reasonable business expenses for the business use of personal equipment in the course and scope of their duties. That means that if they have a cell phone and they're communicating with you at work, you're going to have to reimburse a portion of their cell phone bill. If they are using their home Wi-Fi to connect to your network in order to get their job done, you will probably have to reimburse them for the reasonable value of their Wi-Fi service while they're working from home. If you don't have equipment and they have to go out and purchase a laptop computer or a printer or something that allows them to do their work from home, those would be business expenses incurred by the individual that would be subjected to reimbursement by you. So be careful about that, but you may absolutely require those individuals who are in non-essential business roles to telecommute or work from home, because that will satisfy all of the requirements of the state and the county requirements.
All right, great. Our next question comes from Roger Hammond. He would like to know what protections are available to a business in the city of Santa Clarita from keeping them being evicted if they're not able to pay their rent.
Okay, so the city of Santa Clarita, I don't believe has issued any non-eviction notices, but we are part of the county-wide order, and the county made an order that applied to everything outside of Long Beach and Pasadena that said that there cannot be any residential or commercial evictions for a period of no less than 60 days. And quite candidly, I think on pretty good authority, I can say it's going to be 90 days during the time period that we're dealing with the COVID-19 crisis. That would apply to those businesses here in the city of Santa Clarita. I just have to think I don't believe that there's been any exemption that's been argued by the city from that county provision. At least I haven't seen anything as of yet. I can take a look to make sure that there isn't anything, and I'd be glad to send you that answer, Roger.
That's great. Thanks, Brian. We'll probably want to clarify that to everybody in a follow-up email. Our
Sure
next
thing.
question is from Nola Aronson, Advanced Audiology. Nola would like to know is, has it changed that audiology is an essential healthcare business?
So Nola, it has not since we last spoke. We're still going under the same governing guidelines at the statewide level that indicates that medical providers of essential services are going to be exempted, but they have to be related to the illness or injury. So it basically has to be essential medical personnel. Yours would more be commercial. It would be a matter of convenience rather than medical necessity. We are waiting for further clarification on that particular issue. I've put in a request through our state senator to follow up on that for me.
All right, Brian, I think in the interest of time, we're going to work on wrapping up this webinar. We just want to let everyone know, because we always have a few more questions that have come in online that we haven't gotten to yet. We'll provide those to Brian and see if we can't get some answers, and again, provide those via email to you post this webinar. I want to first of all thank Brian Koegle from Poole, Shaffery, and Koegle for again providing this valuable information to our members in the greater business community. I want to thank the more than 200 people who have joined us today on this webinar. As mentioned earlier, we have additional webinars scheduled. The first coming up is next week, Your Guide to Survive and Thrive on Tuesday, March 31st at 2 p.m. And our second one coming up after this will be in partnership with the Small Business Development Center. And that is going to be scheduled for Wednesday, April 1st. Those are available online at scvchamber.com for registration. In our weekly business update e-blast, we're providing regular updates for everyone, so please take a look at those. And for additional resources on the COVID-19 crisis and resources available to businesses, you can, of course, visit our website, scvchamber.com. I want to thank you again for joining us here today. Please be safe, be healthy, and let us know how the Chamber can help you. Thank you again, Brian and everyone, and have a great afternoon. Thank you.